Thank you, Mr. Chairman. Mr. Cordray, I do accept the objective of trying to simplify things. I'm just in the brief few moments that I've been looking at this. It reminds me of trying to build a gas grill. And we've all been through that once.
I don't like the instruction booklets myself. No.
But, you know, here's H24A, mortgage loan transaction loan estimate. This is the blank form. This is a blank loan estimate that illustrates the application of the content requirements of Section 1026.37, which implies there's about 1,000 other sections before that. This form provides 2 variations of page 1, 4 variations of page 2, and 8 variations of page 3, reflecting the variable content requirements in 1026.37. Then I got to go back to 1026.37. What I'm suggesting to you is the complexity of this is overwhelming, but that's not where I think I want to use a couple of the minutes. Many of the local bankers are concerned about the qualified mortgage definition and whether we're going to get into new kinds of litigation possibilities. And I think you've spent some time, and I'd like to ask for your help in defining where we think this is going to go on the definition regarding whether there's going to be a safe harbor interpretation or whether or not there's going to be a rebuttable presumption. And my reading of what the rebuttable presumption is that in addition to the factual information, there's a series of almost extrinsic evidence that could be introduced about the nature of that transaction. So where do we think this is going to be going with regard to the definition of a qualified mortgage?
So the qualified mortgage rule, which is about the consumer's ability to repay the mortgage, which was something that far too little attention was paid to in the lead up to the financial crisis, and it led to many bad mortgages being peddled that failed in securitizations that brought down the financial system. The idea here, Congress has required that this rule be adopted. The Federal Reserve put forward an initial proposal that then transferred to us, which we've inherited and we are working on to finalize. The idea is that there will be a realm of qualified mortgages that if they meet certain characteristics, there doesn't have to be any attention to ability to repay because the protective features of those mortgages themselves should accomplish that. And then there will be other mortgages outside of that definition, the non-qualified mortgages, if you will, where they will have to document attention to the consumer's ability to repay. It has been conveyed to us loudly and clearly by people across the spectrum that if the qualified mortgage realm is drawn too narrowly, that could upset the mortgage market. That would be a notable example of a rule itself potentially restricting access to credit. We're very concerned about making sure that we don't do that. So we have actually backed up our timing on this rule to consider it further. We gained quite a bit of data from FHFA about mortgages. There's a lot of law that if you gain significant new data and you're going to rest a rule on that, you should give people an opportunity to have input and comment on it, which we have been doing over the course of the summer.
Do you expect much lending outside of the category of what you would call a qualified mortgage?
It's hard to know what may happen in the long run with the mortgage market, but what's been conveyed to us and what we're pretty much convinced by is that in the short run, in the next couple, 3 years, which of course we're all living in the short run, there is unlikely to be a lot of lending done outside of the qualified mortgage circle. And therefore, it's pretty important for us to be more inclusive in terms of what comes within that circle. And that's all input that we're digesting and trying to take into account as we finalize that rule before the end of this year.
There's a provision in the bill that talks about a 3-day window and terms changing during the course of a transaction requiring a new disclosure. I'm concerned and discussed with bankers that you may get to a point where you're getting towards the end of a transaction, what could be the normal discussion in the course of a negotiation about who may be responsible for fixing a basement or something could change the terms, which will require a whole new period of disclosure that may start the process ticking again, which may impact the availability of credit that's guaranteed on that particular day. Is there a way in which there's going to be some flexibility created to allow there to be some movement within the terms of a transaction without having it be triggering a whole new set of disclosures?
So thank you, Congressman. Now you're talking about a different rule, which is the Know Before You Owe Truth in Lending Act RESPA form rule. And part of the proposal there, and it's merely at a proposal stage at this point, we're going to get people's input on it, is that people not be ambushed at the closing table, that they get these disclosures 3 days before they close so they have time to actually review it. You know how the pressure comes at the closing table. There's all the information there. Much of it is required by state law, not by the feds. Much of it is required by the lending institutions themselves for protection. And people are being pushed to just sign, not read it, not understand it. The notion here is that if people can have the information, the key information 3 days before, that gives them a better ability to understand and gauge the transaction they're entering into. We want to try to minimize the impact that could have on potentially tying up a transaction from occurring on the expected date. So that's something we're trying to take account of and get input on through the proposal stage, which is where we are right now. So your comment, which is similar to comments we've heard from others, are things we're trying to take account of and understand how we can avoid having that effect. Although we do think it's very important for consumers to have some time to look at this. It's the biggest single transaction they're likely ever to engage in, and if they do it in a confused basis or a rushed basis where they don't quite understand what they're getting into, they can make bad decisions that will haunt them the rest of their lives and will lead to a bad transaction.
Well, thank you, and I hope that you'll look for flexibility with regard to that. Now, just one last issue that I ask that you spend time considering is the implication on small and medium-sized institutions with regard to requirements for machine readability of documents and the cost that may be associated with whole new kinds of information systems that will have to be obtained in order to do that. I'm hearing a lot about that question.
Thank you, Congressman. We are too, and we're going to look for how we can try to accommodate those concerns.
Thank you.